Hey all, welcome back to TLRS. In the last session, we were writing points from the judgment of South India Church Association Trust, Church Association Church Association Trust versus the Telugu Church Council. We had written points about the importance of competency, which is always there. The court had discussed this point through a number of precedents. Then we have written already about what does the word competent mean. Then the court started giving the rationale for the same. We've written pointers about why does the court consider that pecuniary jurisdiction must always be included in the word competency as opposed to the word jurisdiction, which includes three kinds of jurisdictions, but competency only includes pecuniary jurisdiction and subject matter jurisdiction. So the aim of the court was to justify and figure out why can we exclude territorial jurisdiction from the meaning of the word competent, because the word competent has been used in various provisions of CPC and the word jurisdiction has also been used in CPC, but the word competent means something different from the word jurisdiction. So we have already written points regarding why did the court consider that pecuniary jurisdiction is indispensable. Why is pecuniary jurisdiction so important that it cannot be discounted from the word competent? So the court, for it to be a competent court, must have pecuniary jurisdiction. Court gave you examples from the colonial time judgments. Court gave you examples from the erstwhile predecessors of CPC of 1908, and court showed you why pecuniary jurisdiction must always be there. We took an example also that if pecuniary jurisdiction is excluded from the ambit of the word competent, then we may lead ourselves into an anomalous situation wherein a lower court's judgment could bind a higher court to deciding the same issue. So we took an example that if district court has decided something and now the high court is supposed to hear the same matter, and if we say that the word competent does not include pecuniary jurisdiction, that is for two courts to be of same competence on a case need not be pecuniarily same. So res judicata will apply even between a district court and a high court, thereby binding the high court by the holding of the district court, which is absolutely untenable. It's absolutely indigestible. That's going to be a huge anomaly in the law, because then we will lose all point of having a higher court and creating the hierarchy between the courts. So then court went on to discuss that subject matter jurisdiction is also indispensable, and this we have discussed at length, and we have also written about it, that why subject matter jurisdiction is so important that you cannot do without it. So the competent court would have subject matter jurisdiction for sure. We've taken examples also that what if your family law case, divorce petition or RCR petition ends up in a labor court, then how it will be automatically considered to be unjust. That is why subject matter jurisdiction again becomes indispensable. Then the next point that the court moved on to discuss in the judgment, which is a very important point, and that's the point that we really need to get through, is why is then territorial jurisdiction not so important, not as important, not at par with the pecuniary jurisdiction and subject matter jurisdiction? How do we consider territorial jurisdiction to not be important enough as compared to the other two kinds? Because we are excluding territorial jurisdiction from the meaning of the word competent. So the word jurisdiction will include all three kinds of jurisdictions, but the word competent only includes subject matter and pecuniary. Now, when the court is answering this question, court begins its answering by first looking at the scheme of CPC itself. So first, what court is trying to show you is why it can gather an inference from the reading of Code of Civil Procedure itself and its applicability and its working, that territorial jurisdiction is not as important as subject matter or pecuniary. It's gathering that by showing you how CPC is treating territorial jurisdiction. And it gives you a number of examples. Primary one being section 21 of CPC, where an objection can be raised with respect to a territorial jurisdiction. And so if a decree has been decided, you go in appeal or you go in revision. There in that appellate court or revisional court, you are saying to that court that my decree was passed by a court that lacked territorial jurisdiction. Then CPC is saying that merely by making this objection to that decree will not be disturbed by such appellate court or revisional court. You have to show something in addition to it. What is that thing that you have to show in addition to it? That first of all, that you raise the same objection about lack of territorial jurisdiction in the decree court itself, in the trial court itself, in that lower court. Second, that because of such lack of territorial jurisdiction, you have suffered a miscarriage of justice. If you have not suffered miscarriage of justice, or that you did not raise this objection early on, then it's okay even if the lower court did not have territorial jurisdiction and they still passed this decree. So that is the first instance that the court shows you that CPC is treating territorial jurisdiction to be something less important, something more technical in nature. But then if you see section 21 subsection 2, it is also applying the same rule for pecuniary jurisdiction. So here you can argue, you can be the devil's advocate, and you can argue that even pecuniary jurisdiction is being treated at the same level as territorial jurisdiction, because for that also the law is saying that if there is a lack of pecuniary jurisdiction, then you must also prove miscarriage of justice and that you raise the same objection at the lower level of courts as well. But for pecuniary jurisdiction, in the judgment, the court is explaining to you that if we were to merely take this argument that, okay, pecuniary jurisdiction is also something technical, so why don't we also exclude it? The court says that, okay, if we take this argument and we exclude pecuniary jurisdiction, then it will lead us to the anomalous situation where a lower court's judgment will bind a higher court. That is why we cannot exclude pecuniary jurisdiction when we're talking about the word competent to try in respect to a court. But for territorial jurisdiction, court says that there is no such anomalous situation that will arise if we exclude the word territorial jurisdiction, if we exclude the requirement of having territorial jurisdiction for a court to be considered competent. And moreover, if you see, then they say that moreover, if you see section 21 of CPCs already treating territorial jurisdiction as something technical. And then we wrote about this by dictation. So you have notes on this. Then we move. Then second example that the court takes is that of section 24. Section 24 of CPC is dealing with transfer of cases by the High Court or by the District Court. So for whatever reason, if the High Court or the District Court, either because a party has filed an application with the court to transfer its case, or if the court itself feels that it would be in the interest of justice if the case is transferred, then High Court or District Court, whichever one is the case, they can take a case from a court subordinate to it and try it themselves. So if it's a district court, it can pick up a case that is pending before a civil judge, take that case and tell the civil judge that, okay, I am going to try this case myself because this case is more complicated, it has complex legal issues, or that justice in any other way would be served better if the district court tries this case and not the civil judge. That power is given by section 24. In the same manner, if it's the High Court under section 24, then judge. That power is given by section 24. In the same manner, if it's the High Court under section 24, then High Court, if there's a case pending before a district court and the High Court feels that the justice would be served better, then the High Court can just take that case from district court and withdraw it before itself, and it can say that High Court is the one that's going to try this case and not the district court anymore. What else can they do under section 24? A district court can also move a case from one civil judge's court to another civil judge's court. How will it do it? So if there's a case pending before a civil judge, district judge can take that case from that civil judge and give that case to another civil judge that, okay, we feel that justice would be served better if this civil judge tries it. There can be many reasons for this. We took a number of reasons. We took examples of the Best Bakery case also. So one of the reasons can be that maybe the parties are more convenient. It's more convenient for the parties to approach that second civil judge to whom this case is getting transferred because they live close by to that court. So they're not missing as many hearings as they were already missing in the civil judge number one's court. So the district court can move the case from one civil judge to another civil judge for trial. That power is also given by section 24. Same power is also given to High Court under section 24, where the High Court can move a case which is pending before one civil judge, one district judge. It can pick that case up from that district judge and give it to another district judge to try. It can do that. Or what it can also do is that if the case is pending before one district judge, High Court can take that case. It can either try it himself or give it to another district judge to try. And after some time, if it still feels again that, okay, justice will get served better if we give this case back to the same court from which we withdrew it. So the court can take that case back, and if it's before it, it can just give that case back to the original district judge who was trying it. The High Court can also do this with respect to the civil judges, because the section says that High Court and District Court can do it with respect to judges subordinate to them, courts subordinate to them. For High Court, district judges subordinate to it, even civil judges subordinate to the High Court. For district judge, only civil judges subordinate to it. But if the High Court wants, it can directly take up a case which is pending before a civil judge and move it. It can transfer it, it can withdraw and transfer it. This is the power that Section 24 is giving you. We've written about it, but I'm still giving you a recap because today we will go more into Section 24 for the second part of the lecture. So this can be done under Section 24. Now, what Section 24's language says is that a High Court or a District Court can withdraw and transfer a case in this manner, but the court to which such case is getting transferred should be a court which is competent to try the case. So the second court to which the district judge or the High Court is transferring the case has to be a competent court. So the first court where this case was pending, it was only pending over there because that court had jurisdiction to try it, because that court had pecuniary jurisdiction to try it, because that court had subject matter jurisdiction to try it, because that court had territorial jurisdiction to try it. It was pending over there. Now is the higher court any district or high? So the higher court has picked up that case now and given to another court. Can two district courts have territorial jurisdiction in the same matter? No. They may in some cases where the land is probably divided into falling between two districts, fine. But suppose the other district court does not have the jurisdiction, territorial jurisdiction over this case, which is now being given to that district judge by the High Court or by the High Court, of course. Now, so will you say that that second district judge is now not competent to try that case? So Section 24 cannot be used by High Court to transfer this case from one district to another district. Section 24 nowhere says that you can only transfer it to a court which has jurisdiction. Section 24 says you can transfer such case to another court which is also competent to try. So if competency is going to include territorial jurisdiction, then it will constrict the powers of Section 24 so much that in most cases, the High Court or the District Court in case of civil judge's case will not have another court to which it can transfer such case, because territorial jurisdiction in majority of cases will lie with that one court in which that case is already pending. The purpose of this provision is that the High Court or the district judge should be able to transfer that case from one court to another if the ends of justice need to be met. So to keep that power enabled, you have to understand it in a manner that territorial jurisdiction will not be included in the word competent. And this whole discussion is done by the court in its judgment, and this is what we've also written about. So you see how it will be rendered useless. If you say that competent word includes territorial jurisdiction, then for Section 24, there will hardly be any courts left for the High Court or the District Court to transfer the cases to, because that new court to which it wants to transfer will in majority of the cases not have territorial jurisdiction. But they may have pecuniary jurisdiction. They may have subject matter jurisdiction. And that is what they will have. They must have it. Because from one district to another district, when you're sending, you will send it to a court which has similar pecuniary jurisdiction as the one that was already trying it. And it should also have the same subject matter jurisdiction as the one which was already trying it. Can you pick up a divorce petition which is pending in one state, in one district, and give it to another court in another district, but in that court you're giving it to the labor court or to the rent tribunal? No. Because their subject matter jurisdiction is not there with that second court to which the case is being transferred. So that court is not competent because it lacks subject matter jurisdiction. That is why you will always check for subject matter jurisdiction and pecuniary jurisdiction when it says the word competent. But when it says jurisdiction, that the second court should have jurisdiction, then you have to check for all three, that that court should have territorial jurisdiction also, pecuniary jurisdiction also, and subject matter jurisdiction also. So this was the discussion that the court did with respect to Section 24, that okay, if you still say that if Section 21 argument about rendering territorial jurisdiction to be merely technical in nature is not strong enough, and still you think that territorial jurisdiction is just as important as pecuniary and subject matter, then second thing that the court tells you that we will do is, let's just include the word territorial jurisdiction also within the word competent, and test whether the provisions which use the word competent, like section 24, will this still be workable